Good morning, everyone. The sixth party hearing is in the matter of CFI 85/2023 and is being held by way of video conference before Justice Sir Jeremy Cooke. Any orders or directions made during or after the conclusion of this hearing will be issued on the judge's instructions by the registry. The applicant is represented by Miller Legal Consultants. Lead counsel is Mr. Jonathan Noble. Thank you.
Yes, Mr. Noble.
Your Honor, and may it please the court, we come before you today with an application for a freezing order in the matter of Daikan Dmcc and Mr. Salah Al-Meskan against Poke & Co. Restaurant Limited, which is a company registered, a restaurant operating and registered in the DIFC, and its shareholder and directors, Khalid Mohammed Abdel Magid and Rania Al-Basiouni. We have provided the substantive basis for our claim and our particulars of claim. We're asking now for this freezing order because Mr. Al-Meskan believes that there is a risk that the defendants will dissipate assets or seek to place assets outside of the remit of this court so as to frustrate any order that this court finds in the court of first instance proceedings. And so we have presented now, based on the DIFC Court of Appeal decision and Ithmar Capital Limited versus Investment Inc., which has been further discussed in other decisions, Bosamar International, etc. We believe that we've satisfied the 4-point test to request this freezing order and ask that the court do so today. The amount that we were requesting a freezing order is 1.3 million dirhams. We believe that this is, first of all, this is the amount being requested by the claimants, and it's also not an onerous burden to place on the defendants to make sure that justice is seen in this matter.
Where is the real evidence of any risk of dissipation?
Well, we've referred to, Mr. Al-Meskan has referred to a series of emails and correspondence between the parties over the past year. And we believe that this is a sufficient basis of dissipation. So first of all, a number of discussions, whether they're threats or whether they were good faith discussions about a reorganization of transferring ownership in Poke & Co. to other entities. And we also believe that the defendant's behavior, which is to repeatedly promise payment and then to refuse to make that payment, is sufficient evidence of bad faith and a risk that now that there are proceedings instituted against them, there's a risk that they will seek to dissipate assets or to move them outside of the ambit of this court and prevent justice.
Well, Mr. Noble, a recalcitrant debtor is one thing. A dissipator of assets is another. Now, as I understand it, this the first defendant, the restaurant company, owns a restaurant in the DIFC. Is that right?
That's correct, sir. Yes.
And so there's some assets in the DIFC in the shape of the restaurant.
Ostensibly, there are movables. There's equipment. There also is a bank account that belongs to the entity. While you're correct that a recalcitrant debtor and a person who willfully seeks to dissipate assets are different in form and substance, we would put forward to you that the behavior of these defendants, and particularly the threats to transfer ownership of the shares in Poke & Co. are sufficient to at least satisfy a freezing order request for this 1.3 million dirham. We don't believe that that would be an onerous burden to place on these debtors, and that if indeed this is a serious issue for them, that they would of course be able to challenge this in an appeal.
Well, where's the threat to transfer the shareholdings apart from all the suggestions that they're trying to sell?
I think well, I don't know that we need more than that. I mean, I guess it would be nice to have a smoking gun. That is that defendant number 2 says, I'm going to transfer my assets to a third party so that I don't have to pay you. But I think it's sufficient to muddy the waters and to complicate issues here by claiming that there is a transfer countenanced and ongoing, to create the fear in the claimant's minds that will occur and that will be used in furtherance of this of frustrating the claimant's efforts to seek satisfaction.
But what he's saying, I think, and you can show me if you want to by reference to your exhibit, but what he appears to be saying is, well, I'll sell the company and then you'll get repaid. Isn't that broadly what he's saying? Whether you believe him or not is another question, of course, but isn't that what he's saying?
That is correct. Now, of course, he's been saying that since January of last year.
Yes.
And we have patiently discussed settlement with the debtor and with the debtor's counsel over and over again for the entirety of a year with various promises to pay. So I think that you have to ask yourself at a certain point, when does a promise to pay, to promise to sell shares and pay in good faith, become obfuscation, and reach over to a point where the debtors are no longer acting in good faith and are merely looking to avoid their obligation to repay this debt.
Well, I understand your point, but I'm afraid I'm not with you, Mr. Noble. I can very easily see on the evidence available that we've got someone who's not paying a debt. That much seems tolerably plain. But I don't see any real risk of dissipation of assets that would justify a freezing order. It's not for me to advise you as to how to proceed, and I see that there's an objection to jurisdiction which will have to be dealt with. I'm unclear, but you will need to make it clear if you're going to pursue an application for summary judgment, which I understand you wish to do. But you'll need to make it clear who it is who is said to really owe the debt. Is it the first defendant, the second or the third defendant? On the face of it, I'm not very impressed with the idea that the second or third defendant has given a guarantee as such. And so the issue may be whether or not this loan was, quote, personal, or a loan to the company, or there's joint and several liability between the first and second defendant. I don't know. But if you're going to pursue a claim for summary judgment, which on the face of it would appear to be the appropriate route for someone who's not paying a debt, you're going to have to make that clear. And the court will determine any issues that arise. There doesn't appear to be any reason why you shouldn't proceed with a claim against the first defendant for summary judgment, regardless of the contestation of jurisdiction by the second and third. But all of that ought to be capable of being dealt with fairly shortly in any event, and it's a matter for you how you want to proceed. But I'm afraid I'm not with you on the freezing order, simply for the reasons I've given.
Thank you very much, Your Honor.
Okay. Do you want to give the court any indication as to how you intend to proceed, or do you want to reflect on that?
I think we well, under Part 8, yes, we would like to proceed with an application for a summary order. Although it was my understanding that summary proceedings under DIFC are not available to Part 8 applicants.
Well, you should have brought your claim under Part 7. I mean, it's easily changed, and that's what you ought to do, because on the face of it, there's likely to be a contest. However restricted you think that's likely to be in terms of the evidence. But on the face of it, I don't think one could say this is a case where there are no issues of fact which have to be explored, including the one I've just mentioned, which is the question as to which defendant is liable. So again, it's not for me to advise you, but Part 7 would appear the appropriate procedure, and then you get on and seek summary judgment under your Part 7 in the ordinary way. I'm not sure how familiar you are with the DIFC procedures, whether you're a regular or not.
Well, I'm not a regular. I've appeared previously as a co-counsel, and we had success under a Part 8 claim previously. So I understand that the defendants are seeking to muddy the waters here and to call into question some of these issues. From our point of view, a Part 8 claim is appropriate. But your thoughts are well taken and appreciated, and will be taken under advisement.
Well, what I'm saying to you is that I don't see this as a Part 8 claim. This is they're going to be issues of fact which have got to be resolved. They may be easily resolved on affidavit evidence. We've got all the WhatsApps and so on and so forth that show an admission of indebtedness and so on and so forth. But even so, they're fact issues that arise. So Part 7's the right way to go. And if you want summary judgment, you make the usual form of application. The only issue probably is to decide whether or not how the timing works in the context of the second and third defendants contesting jurisdiction as well. But anyway, there you are. Up to you. You'll have to make your decisions and get on with it.
Thank you, Your Honor. Best wishes for a Happy New Year to you.
And to you too. If you wouldn't mind signing out, I'll just have a quick word with the associate. Thank you.
Thank you, sir. Good day.